And we're now live on Earth Action Hub. Thank you everyone for being here with us and being our viewers and participating in this amazing talk with Kirsty. And I'm sure we're all looking forward to hear about her work, her lighter work, and what's going on in law, in the protesting for the planet. I wish to thank Susie Bascon and Peace Brigade United Kingdom for facilitating this talk and make it happen. And I now pass it to Jessica, also co-founder of Earth Action Hub, like me, to further take over the stage. Thank you very much.
Thanks, Paola. I just want to quickly introduce Kirsty before giving her the virtual floor. Kirsty Brimelow is a barrister and she's defended peaceful protesters for nearly 3 decades. She's a recognised expert on the law of peaceful protests, as well as an experienced investigator on rights of both humans and animals displaced under threat. So enough from us. You want to hear from Kirsty. So the floor is yours, Kirsty. Thank you.
Thank you very much, and for the introduction. As Jessica has said, I practice predominantly in England and Wales, but I also practice in international human rights, which means that I have appeared in courts and intervened in cases internationally and globally. Peaceful protest has become something of an expertise over the years because there are concerns by many states that the tactics of protest have changed, and so much so that the disruption caused is outweighing the right to protest. I'm going to speak a little about the history of protest and then move on to the legal framework. I'm going to keep it light, so hopefully you're not all going to just switch off at the law point, those of you who aren't lawyers, and then come on to some particular challenges with a focus on England and Wales. And there's a bill currently going through Parliament in England and Wales, which will be restricting rights to peaceful protest, and that in itself has led to protests. So we're now seeing protests against protest rights or restriction of protest rights. So it's getting sort of ever evolving. Now, peaceful protest was born in Britain, and it's evolved over the decades from a repressive way of dealing with protests to a way which has settled in international law, whereby any force against protests should be a last resort, and interference with the right to peaceful protest should always be minimal. It used to be very repressive in England and Wales, and many will obviously know of the suffragettes as a prime example of direct action protest, which was treated and responded to by the state with a real iron fist. And the women, the suffragettes, were really treated very violently in the state response. Environmental protests, well, environmental protesters in the UK had not actually been sentenced to prison in the UK directly for the offence from the protest since 1932. When ramblers inspired by Gandhi who'd made a highly publicised visit to Darwin in the northwest of England, where he'd encouraged the boycotting of Lancashire cotton. And inspired by Gandhi, ramblers tried a mass protest to force open access to Kinder Scout up in the north in Derbyshire. And there was violence also in that protest, and imprisonment resulted. Now, there'd been no direct action protesters sent to prison, environmental protesters sent to prison since 1932 until 2018. And this was a case I defended in, and I took on appeal. And this related to protesters who were protesting against fracking, again in the north of England. And a little summary of what it was about is that in January 2017, Quadrilla was granted a license to explore for shale gas by the use of the process known as hydraulic fracturing, fracking as it's become known colloquially, at a site just off Preston New Road in Lancashire. And in July 2017, lorries were travelling to the site to deliver the fracking equipment when they were stopped by protesters. And 4 of those protesters climbed onto the cabs of the lorries and remained there between 2.5 and 3.5 days. One carriageway was blocked, and the men were tried on account of public nuisance contrary to common law. In 2018, they were convicted by a jury at Preston Crown Court and later sentenced to 15 months and 16 months imprisonment. The appeal against sentences, which is the point where I came in on sentence, and then I came in on the appeal. It was expedited because there were protests against the imprisonment of these men. And there were petitions, there was a huge amount of public upset that these men had been given prison sentences at all, and also the length. Now, the appeal against the sentences was expedited, heard by the Court of Appeal 3 weeks later, and presided over by the senior judge of England and Wales, so the Lord Chief Justice. And the Court of Appeal quashed the sentences of imprisonment and concluded that community sentences with a punitive element such as curfew or work were the appropriate sentences. However, due to the period that the men had spent in custody, the Court of Appeal imposed conditional discharges of 2 years, which basically means provided that they committed no other offences, were convicted of no other offences in that 2-year period, then that would be the end of that sentence. And that would mean that matter was then spent in terms of a rehabilitation of offenders programme, so they wouldn't thereafter have to declare it. It's pretty much the lightest sentence you can get in England and Wales, a conditional discharge. You can get an absolute discharge, but that is incredibly rare. So it's pretty much the lowest you can get in a criminal justice system. Now, the Court of Appeal importantly reaffirmed that direct action protests fall within the scope of Articles 10 and 11 of the European Convention on Human Rights. And whilst Strasbourg, we're looking at the Strasbourg cases, whilst the Strasbourg cases don't say that there is a bright line where those convicted of peaceful protest should never be sent to prison, it is of importance that in all the cases where detention of protesters was upheld in the European cases, they all involved violence or could be distinguished as relating to detention prior to charge with Bail Act and breach of peace considerations. So the Court of Appeal reaffirmed in the fracking case the light touch that criminal courts should take in sentencing for crimes committed in the course of peaceful protest. And this has subsequently been reaffirmed in a case, a civil case. In fact, I was in the Court of Appeal with that, and that was related to breach of injunctions, which have been applied for and granted to Quadrilla. Again, it was a fracking site, and then more recently, there's been reaffirmation in the Supreme Court. Now, internationally, outside the European Convention, the ICCPR is applicable to most states, those that have obviously ratified it. It's one of the big human rights treaties. And Article 21 there recognises the right of peaceful assembly, restrictions in all these with the right to protest, which is freedom of expression and assembly. Any restrictions should be narrow. They should be narrowly pursued by the state, and they have to be linked to a legitimate aim. And so those restrictions have to be linked to a legitimate aim of, for example, preventing public disorder, upholding public order. So the restrictions can't be imposed, in other words, just because the state considers it would like to impose restrictions. Now, there's also internationally, in terms of where you could write any complaints, there's the UN Special Rapporteur on the rights of freedom of peaceful assembly and association. And importantly, the state also has a positive duty to protect and facilitate protest. Now, in the UK, we've seen a bill which is currently going through Parliament, and we've seen protests quite often under the hashtag Kill the Bill, where there are clauses which are restricting protest. Now, the reason for the bill is said to be because the police don't have sufficient powers, said to be a change of tactics by movements such as Extinction Rebellion, and also Black Lives Matter, and cost. What is interesting, I was actually speaking, giving evidence to an all-parliamentary group yesterday, and what was quite interesting there was it was raised that questions were asked in Parliament back in 1909 about how much did it cost to police the suffragettes, and so in some ways the same questions are here. And we obviously all look back at the suffragette movement and we see how much they were on the right side of history. Now, the bill, there's in England and Wales, it'd be probably very familiar to those of you who are based or work in English law or are part of activist movements or social movements within England and Wales. It's relevant as well because internationally we do look around and see real repression of protests, and we've seen it in recent weeks, particularly in Colombia, where there seems to have been live ammunition fired upon protesters, which would not be justified in any way under international law. But looking at a liberal democracy as the UK is, it's therefore interesting to kind of look at a trend of restrictions on freedom of expression. And first of all, the policy itself within the bill, is it needed? Is there a change in protest tactics? My view, having acted in these cases probably for over 2 decades now, is in fact the tactics don't really change that much. I mean, they might get slightly more creative, but essentially the tactics with direct action involve disruption, involve blockading, involve causing, well, I suppose raising attention and reaching the media. Perhaps in some ways the props are a little bit more jauntier than they were in the past. Certainly with Extinction Rebellion, we saw in the West End a couple of years ago a huge boat there in order to highlight the climate change crisis. So is it needed? Is it required? Are there already sufficient powers? I would say there's already sufficient powers under the Public Order Act, which is our domestic legislation in England and Wales, and other common law offences. The second issue with the bill, does it have legal certainty? That means, is it precise enough? Or is it too wide? And also, obviously, is it compatible with rights to freedom of expression as expressed in Article 10 of the European Convention on Human Rights, and also freedom of assembly under Article 11? And the third issue is there's really a lack of safeguards in the bill. And by safeguards, there's no appeal system concerning the conditions that the police could impose on static protests, which is what the bill is aimed at. It's looking at static protests as opposed to moving protests, which already have quite a number of restrictions upon them and conditions that the police can impose. And within the bill, there's nothing around the positive duty of the state to facilitate protests. And for my part, as a practitioner, that is one aspect that is always worth underlining and can be easily lost. And really, with what does that mean on facilitating protest? Well, I would have liked to have seen more thought given to dialogue between state and protesters in advance, so that there can be understanding on both sides as to how the protests will proceed and what is to be expected and what conditions actually mean. And we saw the downside where dialogue doesn't occur in the vigil which happened in England and Wales at Clapham Common, where there was a vigil for a murdered woman, Sarah Everard. And the protesters, the Reclaim the Streets protesters who were originally organising the protest, there was a court case on it because of lack of clarity on whether the protest could go ahead. Eventually they cancelled the protest, but the police had a space where they could in fact have communicated and worked with the leaders. Because they didn't, what happened was, I'm saying protest, it was more of a vigil, but what happened was the vigil went ahead in any event, but with disparate groups of people, and there was no lead organizer that could coordinate with the police. And the police sort of doubled down, really, once the litigation started, and doubled down in stopping any negotiation. So very briefly, I'm going to go through the bill and what I would say about it. Is there legal certainty? No. The issue here is that there's a new lower legal test where conditions can be imposed upon peaceful protests, which might cause serious unease, alarm or distress now to somebody else in the vicinity. Now, if you think about that, that pretty much is what a protest is. And so the test has been lowered upon which conditions could be imposed. Potentially, is there a legitimate aim here? Well, lowering noise is not a legitimate aim, arguably. It's something different to maintaining public order. And there's a lot of cases on the offensive nature sometimes of protests, the unruliness, particularly those who might not agree with the nature of the protest, but that is all part of it and needs to be safely guarded. So what proposed basis for imposing conditions if noise might cause people serious unease? It's hard to think that this is proportionate to a legitimate aim of law and right to protest. Many of us will have experienced serious unease just pushing through crowds of people who are in the midst of some demonstration, and that should not be sufficient to impose a condition. Now, safeguards, there's limited safeguards in the bill to ensure that the police use their powers lawfully, in that if the legal test is met and if the police reasonably believe that conditions are necessary, then they can go ahead and impose them. There is a challenge that protesting groups could make, and that is using judicial review. Many of you will be familiar with that, and that is where it's saying that this decision was one which is unlawful. However, the difficulty with judicial review is it can be expensive. We've seen increasingly that costs of judicial review actually can be a barrier to people accessing that means of justice. And it's certainly in my experience as a practitioner, I've seen the costs from the state side, even getting to the just a very short period moving on to getting permission, the costs can be incredibly high. And obviously that is going to put off groups which often usually simply don't have the money to risk it. So there really should be some kind of appeal inbuilt, which is not going to be draconian in terms of costs. The other issue with judicial review is, particularly with backlogging courts, I'm talking about England and Wales, but I mean globally, the backlogging courts on challenging anything within a court system can be incredibly difficult and also quite inaccessible to people, because they don't really understand how to approach it, and the whole idea of getting a lawyer somehow can be quite hard. So the other issue there is the time that it might take. And if you're getting conditions imposed shortly before the protest is about to happen, you just may not have time to get the case up before the court and know how to do it. The final point I'm just going to mention before asking on any opening up for any questions is criminalisation. There's an additional aspect here in this bill where currently protesters, to be criminalised potentially, must knowingly breach a condition of the protest. The new clause means that people would commit the amended offence if they disobeyed a condition they knew or ought to have known was in force. So again, query whether there should be criminalisation for somebody breaching a condition that they did not know existed, but merely ought to have known. So that is an issue. Any criminalisation of peaceful protest is one which always should be considered very carefully and challenged, because generally the law is that peaceful protesters should not be subjected to criminalisation. The final point is that there's a rather concerning clause where currently protests must involve at least 2 people to engage police powers in the Public Order Act. But here there's an amendment to a 1-person protest could be made subject to conditions based only on likely noise. So not even on the link to serious public disorder and so on, but only on noise. And that is difficult to see how that could be lawful. So a lot of issues there, which is why Kill the Bill has been trending as a hashtag. And we've seen many protests. It's with a context perhaps of freedom of expression restrictions and enlargements and complaints within universities. And we can see a global context of movements of protest which are linking up internationally. And we can see that these are happening because the issues that are underlying these protests are global issues, and obviously climate change and Black Lives Matter are 2 very powerful examples of that. So a lot to challenge and a lot to be concerned about in relation to peaceful protest. But open up really for any questions.
Thank you, Kirsty. You have a wealth of knowledge. Thank you so much for sharing with us, and particularly such a relevant topic for young people, but for everyone, because protests have been happening a lot in the past couple of years for different reasons. But there is a question here from Enrico, who asks, Kirsty, in the position of a peaceful protest organiser, what actions would you recommend to deal with vandalism or disorder situations out of control?
Yes, I mean, that's a very good question, because obviously the issue with many protests is that they can be infiltrated and often are infiltrated by people with different agendas. And those agendas can be violent, and then it takes it outside the scope of peaceful protest. As to what action I'd recommend, I think that's a really difficult one, because it depends on the actual specific organisation, where it's happening, how big it is, and what liaison you have with the police. But this is where you would be hoping to have a reasonable relationship with the police to discuss with them concerns that you might have on infiltration of vandalism. Now, there might be specific groups that you fear might infiltrate, have been threatening to infiltrate, that you don't want to, and in which case that would be where some kind of relationship with the police would be very helpful. And then if it all kind of went wrong in that vandalism did occur and criminal offences were occurring, you as an organiser would be in a position of being able to say, well, you had liaised with the police about these specific fears and cooperated with them as best as you could and asked for their assistance in preventing any crimes within or on the fringes of your peaceful protest. So I think it's quite fact specific, but that's where when I first looked at the clauses of the bill, I actually wrote a piece on it in the Guardian about a month ago, which I obviously, because I wrote it, I'd recommend you go and read it. But when I first looked at the clauses of the bill, one thing that just struck me was what a shame that there's not something more creative on actual partnership with the police, because when it does work, and it can work in England and Wales, and I've seen it work, and it's got better, where there's a there's 5 steps that police take before arrest of a peaceful protester, and it's kind of 5 steps of persuasion that they desist, and that is the law as it should be applied. It's giving the ultimate chance of, we're now saying you are committing a criminal offence, but we are giving you all these chances to remove yourself from this situation. So when that works, that's great. I have been in an Extinction Rebellion case where I saw it not working, and that was a case in 2019. And I was representing one peaceful protester, and all of them had glued their hands to the hotel of the doors of the Intercontinental Hotel in Park Lane in protest against the International Petroleum Week, which was taking place inside there. And I represented one of the protesters who's quite well known actually, so, on YouTube. And some of the other protesters represented themselves, and there was one woman who, it was on the body worn cam, the officer, as her hand had come free, the glue had unstuck, had come free, the officer asked her, would she now move away, and otherwise she would be arrested. And she had a discussion with another woman there and said, well, I think I will move away now. And then the sergeant came in and said, arrest her. And as a result of that, she was prosecuted. The case was part heard and moved around London to different magistrates' courts over 3 hearings with, I think, at least 1 or 2 preliminary hearings. Huge expense on that. And of course, she was acquitted. So you could just see there that was where it goes wrong. And if only you could have more sense. And she spent about at least 14 hours in police custody. They locked her up in the cells, as all of them. They were all at least 13 hours in the cells. My client also was acquitted, quite rightly. So you kind of see this disparity that sometimes you kind of get overreach from the police. And so that's why, for me, it's a shame that it's not within the bill to emphasise on dialogue, on partnership, on duty to facilitate peaceful protests. Because when you're presenting more powers, if the police are not trained properly on the underlying rights to protest, then you can get this power overriding, and because they can, arrests then happen, which actually don't benefit anybody.
Thank you for that answer. I think things that I have learned from this is it's really important, if you do want to peacefully protest, is to have that communication with the police and your state. Like, I never really thought about that, so it's a really important point to highlight, almost to protect yourself as well, if those people do come in and sort of sabotage your peaceful protest, and also, I guess, to read up and know your rights in peaceful protests and know the law. I think a lot of us, I mean, I certainly went out into some of the protests and not really knowing anything really, and just you get caught up in it. So it is really a very important topic to talk about. Do we have any more? Let me just read the questions. Everyone's saying how fascinating this is. Isaac asks, is it illegal to peacefully protest in Europe? No, so it's not. The European countries are all covered. They're all covered by the European Convention. So Article 10 and Article 11 would apply. Now, the right to protest is a qualified right. Now, so what that means is it's not absolute, like the right to life is absolute. And that means that the state can restrict, but that restriction on your right to protest, the interference with your right to protest, has to be only in specific circumstances where it's linked to a legitimate aim. So, for example, in England and Wales, we have Public Order Act offences, which is maintaining public order. And if your protest is going over where there's threats of violence, perhaps, or any other matter which might come into a Public Order Act, that's where your right is being interfered with. And then the restriction has to be proportionate. So that is where the police will say, actually, you're over the line here on trespass now, on public nuisance. We've allowed this for X number of hours. However, on balancing public rights against you as your individual rights, we're now asking you to step away. So it's always a proportionate exercise, and it's a proportionate exercise if you're prosecuted as well. Is it proportionate for you to be prosecuted for what you've done, or in fact, should you be given some out of court disposal, like a penalty notice for public disorder? So, and that's another thing that I remember when I first started as a practitioner, I used to see far more out of court disposals, like bindovers they were called, and we other types of certainly out of court, like a caution. We just don't see so many now. It seems to be prosecute or not, and it would be better if there was more use of an alternative to actually prosecuting. Is there any social media which you can be contacted? Yes, I'm on Twitter. You don't know that? Yeah, I'm actually on Twitter under my own name. So it's Kirsty _Brimelow. Yeah, you can contact me on Twitter. Yeah, we'll pop that in the chat as well for everyone. I really don't want to wrap us up because it's so interesting, and I'm sorry that we do have to wrap up because it's just such a relevant topic, and you have so much knowledge to share. But I just want to thank you, Kirsty, for giving up your time. I know you are very busy, especially, it's a weekend. So thank you so much for coming and sharing your knowledge with us, because it's a very relevant topic. So thank you so much. Oh yeah, your Twitter is now in the chat for everyone to find. So thank you, Kirsty. Thank you everyone for watching, and enjoy the rest of your day.